Ministry of the Interior and Kingdom Relations. The Constitution of the Kingdom of the Netherlands, 2018. Chapter 1. Fundamental Rights. Article 1. All persons in the Netherlands shall be treated equal in equal circumstances. Discrimination on the grounds of religion, beliefs, political opinion, race, or sex, or on any other groups whatsoever shall not be permitted. Article 2. 1. Dutch nationality shall be regulated by Act of Parliament. 2. The admission and expulsion of aliens shall be regulated by Act of Parliament. 3. Extradition might take place only pursuant to a treaty. Further regulations concerning extradition shall be laid down by Act of Parliament. 4. Everyone shall have the right to leave the country except in the cases laid down by Act of Parliament. Article 3. All Dutch nationals shall be equal eligible for appointment to public service. Article 4. Every Dutch national shall be an equal right to elect the members of the general representative bodies and to stand for elections as a member of those bodies, subject to the limitations and exceptions prescribed by Act of Parliament. Article 5. Everyone shall have the right to submit petitions in writing to the competent authorities. Article 6. 1. Everyone shall have the right to profess freely his religion or belief, either individually or in community with others, without prejudice to his responsibility under the law. 2. Rules concerning the exercise of this right, other than in buildings and enclosed places, may be laid down by Act of Parliament for the protection of health, in the interests of traffic and the combat of prevent disorders. Article 7. 1. No one shall require prior permission to publish thought or opinions through the press without prejudice to the responsibility of every person under the law. 2. Rules concerning radio television shall be laid down by Act of Parliament. There shall be no prior supervision of the content of a radio or television broadcasts. 3. No one shall be required to submit thoughts or opinions for prior approval in order to disseminate them by means other than those mentioned in the preceding paragraphs, without prejudice to the responsibility of every person under the law. The holding of performances open to persons younger than 16 years of age may be regulated by Act of Parliament in order to protect good morals. 4. The preceding paragraphs do not apply to commercial advertising. Article 8. The right of association shall be recognized. This right may be restricted by Act of Parliament in the interest of public order. Article 9. The right of assembly of demonstration shall be recognized without prejudice to the responsibility of everyone under the law. 2. Rules to protect health in the interest of traffic and the combat of prevent disorders may be laid down by Act of Parliament. Article 10. 1. Everyone shall have the right to respect for his privacy without prejudice to restrictions laid down by or pursuant to Act of Parliament. Rules to protect privacy shall be laid down by Act of Parliament in connections with the recording and dissemination of personal data. 3. Rules concerning to the rights of persons to be informed of data recorded concerning them and of the use that is made thereof, and to have such data corrected shall be laid down by act of Parliament. Article 11. Everyone shall have the right to inviolability of his person without prejudice of to restrictions laid down by pursuant to Act of Parliament. Article 12. 1. Entry into a home against the will of the Yokopan shall be permitted only in the case of laid down by or pursuant to Act of Parliament by those designated to purpose by or pursuant to Act of Parliament. 2. Prior identification and notice of pursuit shall be required in order to enter a home under the preceding paragraph, subject to the exceptions prescribed by Act of Parliament. 3. A written report of the entry shall be issued to the occupant as soon as possible. If the entry was made in the interest of state security or criminal proceedings, the issue of the report may be postponed under rules to be laid down by Act of Parliament. A report needs to be issued in cases to be determined by Act of Parliament where such issue will never be in the interest of state security. Article 13. The privacy of correspondence shall not be violated except in the cases laid down by Act of Parliament by order of the courts. The privacy of the telephone and telegraph shall not be violated except in the cases laid down by Act of Parliament by or with the authorization of those designated for the purpose by Act of Parliament. Article 14. 1. Expropriation may take place only in the public interest and on prior assurance of full compensation, in accordance with regulations laid down by or pursuant to Act of Parliament. 2. Prior assurance of full compensation shall not be required if in an emergency immediate expropriation is called off. 3. In cases laid down by or pursuant to Act of Parliament, there shall be a right to full or partial compensation if in the public interest the competent authority destroys property or renders it unusable or restricts the exercise of the owner's rights to it. Article 15. Other than in the cases laid down by or pursuant to Act of Parliament, no one may be deprived of his liberty. 2. Anyone who has been deprived of his liberty other than by order of a court may request a court to order his release. In such case, he shall be heard by the court within a period to be laid down by Act of Parliament. The court shall order his immediate release if it considers the deprivation of liberty to be unlawful. 3. The trial of a person who has been deprived of his liberty, the pending trial shall take place within a reasonable period. 4. A person who has been lawfully deprived of his liberty may be restricted in the exercise of fundamental rights insofar as the exercise of such rights is not compatible with the deprivation of liberty. Article 16. No offense shall be punishable unless it was an offense under the law at the time it was committed. Article 17. No, no one may be prevented against his will from being heard by the courts to which he is entitled to apply under the law. Article 18. 1. Everyone may be legally represented in legal and administrative proceedings. 2. Rules concerning the granting of legal aid to persons of limited means shall be laid down by Act of Parliament. Article 19. 1. It shall be the concern of the authorities to promote the provisions of sufficient employment. 2. Rules concerning the legal status and protection of working persons and concerning co-determination shall be laid down by Act of Parliament. 3. The right of every Dutch national to a free choice of work shall be recognized without prejudice of the restrictions laid down by or pursuant to Act of Parliament. Article 20. 1. It shall be the concern of the authorities to secure the means of subsistence of the population and to achieve the distribution of wealth. 2. Rules concerning entitlement to social security shall be laid down by Act of Parliament. Dutch nationals residing in the Netherlands who are unable to provide for themselves shall have a right to be regulated by Act of Parliament to aid from the authorities. Article 21. It shall be the concern of the authorities to keep the country habitable and protect and improve the environment. Article 22. The authority shall take steps to promote the health of the population. 2. It shall be the concern of the authorities to provide sufficient living accommodation. 3. The authorities shall promote social and cultural development and leisure activities. Article 23. 1. Education shall be the constant concern of the government. 2. All persons shall be free to provide education without prejudice of the authority, right of supervision, and with regard to forms of education designated by law, the right to examine the competence and moral integrity of teachers to be regulated by Act of Parliament. 3. Education provided by public authorities shall be regulated by Act of Parliament, paying due respect to everyone's religions or belief. 4. The authorities shall ensure that primary education is provided in a sufficient number of public authority schools in every municipality and in each of the public bodies referred to in Article 132a. Deviations from these provisions may be permitted under rules to be established by Act of Parliament on condition that there is this opportunity to receive this set of education, whether in a public authority school or otherwise. 5. The standards required of schools financed either in part or in full from public funds shall be regulated by Act of Parliament, with due regard, in the case of private schools, to the freedom to provide education according to religions or other belief. 6. The requirements for primary education shall be such that the standards both of private schools fully financed from public funds and of public authority schools are fully guaranteed. The relevant provisions shall respect in particular the freedom of private schools to choose their teaching aids and to appoint teachers as they see fit. 7. Primary schools that satisfy the conditions laid down by Act of Parliament shall be financed from public funds according to the same standard and as public authority schools. The condition under which private secondary education and pre-university education shall receive contribution from public funds shall be laid down by Act of Parliament. 8. The government shall submit annual report on the state of education to the States General. 2.2. The King and the Ministers. The government shall comprise the King and the Ministers. 2. The ministers and not the King shall be responsible for acts of government. Article 43. The Prime Minister and the other ministers shall be appointed and dismissed by royal decree. Article 44. 1. Ministers shall be established by royal decree. They shall be headed by a minister. 2. Non-departmental ministers may also be appointed. Article 45. 1. The ministers shall together constitute the cabinet. 2. The Prime Minister shall share the cabinet. 3. The cabinet shall consider and decide upon overall government policy and shall promote the coherence thereof. Article 46. 1. State Secretaries may be appointed and diminished by royal decree. 2. A State Secretary shall act with ministerial authority in place of the Minister in cases in which the Minister considers it necessary. The State Secretary shall observe the Minister's instructions in such cases. Responsibility shall rest with the State Secretary without prejudice to the responsibility of the Minister. Article 47. All acts of Parliament and royal decrees shall be designated by the King and by one or more ministers or State Secretaries. Article 48. The royal decree appointing the Prime Minister shall be countersigned by the latter. Royal decrees appointing or diminishing minister and State Secretaries shall be countersigned by the Prime Minister. Article 49. Upon attempting office, ministers and State Secretaries shall be swear on oath or make an affirmation and promise in the presence of the King in the manner prescribed by Act of Parliament, and they have not done anything which may legally debar them from holding office, and shall also swear or promise allegiance to the Constitution and that they will faithfully discharge their duties. Chapter 3. The States General. 3.1. Organization and Composition. Article 50. The States General shall represent the entire people of the Netherlands. Article 51. 1. The States General shall consist of a lower house, Tweede Kamer, and an upper house, Eerste Kamer. 2. The lower house shall consist of 150 members. 3. The upper house shall consist of 75 members. 4. The two houses shall be deemed a single entity when they meet in joint sessions. Article 52. 1. The duration of both houses shall be 4 years. 2. The duration of the upper house shall be amended accordingly if the duration of the provincial councils, provincial staten, is altered by act of Parliament to a term other than 4 years. Article 53. 1. The members of both houses shall be elected by proportional representation within the limits to be laid down by Act of Parliament. 2. Election shall be by the secret ballot. Article 54. 1. The members of the lower house shall be elected directly by Dutch nationals who have attained the age of 18, with the exception of any Dutch national who may be excluded by Act of Parliament by virtue of the act that they are not resident in the Netherlands. 2. Anyone who has committed an offence designated by Act of Parliament and has been sentenced as a result by a final and conclusive judgment of a court of law to a custodial sentence of not less than 1 year and simultaneously disqualified from voting shall not be entitled to vote. Article 55. The members of the upper house shall be chosen by the members of the provincial councils and the members of an electoral college as referred to in Article 132a, paragraph 3. The election shall take place not more than 3 months after the election of the members of the provincial councils, except in the event of the dissolution of the House. Article 56. To be eligible for membership of the States General, a person must be a Dutch national, must have attained the age of 18 years, and must not have been disqualified for voting. Article 57. 1. No one may be a member of both houses. 2. A member of the States General may not be a minister, state secretary, member of the Council of State, member of the Court of Audit, Algemet Rekenkamer, National Ombudsman of Deputy Ombudsman, member of the Supreme Court, or Procurator General of or Advocate General at the Supreme Court. Notwithstanding the above, a Minister of Secretary or State Secretary who has offered to tender his resignation may combine the said office with membership of the States General until such time as a decision is taken on such designation. 4. Other public functions which may not be held simultaneously by a person who is a member of the States General or of one of the houses may be designated by Act of Parliament. Article 57a. The temporary replacement of a member of the State General during pregnancy and maternity leave or during illness shall be regulated by Act of Parliament. Article 58. Each house shall examine the credentials of its newly appointed members and shall decide with due reference to rules to be established by Act of Parliament any dispute arising in connection with the credentials or the election. Article 59. All other matter pertaining to the right to vote and to elections shall be regulated by Act of Parliament. Article 60. Upon accepting office, members of the houses shall swear an oath to or make an affirmation and promise there before the House in the manner prescribed by Act of Parliament, than they have not done anything which may legally debar them from holding office, and shall also swear or promise allegiance to the Constitution, and that they will faithfully discharge their duties. Article 61. 1. Each house shall appoint a speaker from among its members. 2. Each house shall appoint a Secretary General who, like the other officials of the two houses, may not be a member of the States General. Article 62. The Speaker of the Upper House shall be preside when the two houses meet in joint session. Article 63. Financial remuneration for members and former members of the State General and their dependents shall be regulated by Act of Parliament. The Houses may pass a bill of the matter only if at least two-thirds of the votes cast are in favor. Article 64. 1. Each of the houses may be dissolved by royal decree. 2. A decree for dissolution shall also require new elections to be held for the house which has been dissolved, and the newly elected house to meet within 3 months. 3. The dissolution shall take effect on the day on which the newly elected house meets. 4. The duration of a lower house that meets following a dissolution shall be determined by Act of Parliament. The term may not exceed 5 years. The duration of an upper house that meets following a dissolution shall end at the time and with the duration of the dissolved house will have ended. 3.2. Procedure. Article 65. A statement of the policy to be pursued by the government shall be given by or on behalf of the King before a joint session of the two houses of the State General that shall be held every year on the third Tuesday in September or on such earlier date as may be prescribed by Act of Parliament. Article 66. 1. The sittings of the States General shall be held in public. 2. The sittings shall be held in camera if 1/10 of the members present to require, or if the Speaker considers it necessary. 3. The House or the two houses meeting in joint session shall be decide whether the deliberations are to continue and the decisions to be taken in camera. Article 67. 1. The two houses may deliberate or take decisions either separately or in joint session only if more than half of the members are present. 2. Decisions shall be taken by majority. 3. The members shall not be bound by a mandate or instructions when casting their votes. 4. Voting on items of business not relating to individuals shall be oral and by roll call in request by one member. Article 68. Ministers and state secretaries shall provide orally or in writing the houses either separately or in joint sessions with any information requested by one or more members, provided that the provision of such information does not conflict with the interests of the state. Article 69. 1. Ministers and state secretaries shall have the right to attend sittings of the States General and may take part in the deliberations. 2. They may be invited to present at sittings of the houses of the States General, meeting either separately or in joint session. 3. They may be assisted at the sittings by persons nominated by them. Article 70. The two houses shall jointly and separately have the right of inquire and to be regulated by Act of Parliament. Article 71. Members of the State General, Ministers, State Secretaries, and other persons taking part in deliberations may not be prosecuted or otherwise held liable in law for anything they say during the sittings of the States General or of its committees, or for anything they submit to them in writing. Article 72. Each house of the States General and the two houses in joint sessions shall draw up rules of procedure. Chapter 4. Council of State, Court of Audit, National Ombudsman, and Permanent Advisory Bodies. Article 73. 1. The Council of State or a division of the Council shall be consulted on bills and draft orders in Council, as well as proposals for the approval of treaties by the States General. Such consultation may be dispensed with in case to be laid down by Act of Parliament. 2. The Council or a division of the Council shall be responsible for investigating administrative disputes where the decisions has to be given by royal decree, and for advising on the ruling to be given in the said dispute. 3. The Council or a division of the Council may be required by Act of Parliament to give decisions in administrative disputes. Article 74. 1. The King shall be President of the Council of State. The heir presumptive shall be legally entitled to have a seat on the Council of attaining the age of 18. Other members of the Royal House may be granted a seat on the Council by or in accordance with an Act of Parliament. 2. The members of the Council shall be appointed for life by royal decree. 3. They shall cease to be members of the Council on resignation or on attaining an age to be determined by Act of Parliament. 4. They may be suspended or dismissed from membership by the Council in instances specified by Act of Parliament. 5. Their legal status shall in other respects be regulated by Act of Parliament. Article 75. 1. The organization, composition, and powers of the Council of State shall be regulated by Act of Parliament. 2. Additional duties may be assigned to the Council or a division of the Council by Act of Parliament. Article 76. The Court of Audit, Allgemeine Rekenkamer, shall be responsible for examining the state's revenues and expenditures. Article 77. 1. The members of the Court of Audit shall be appointed for life by royal decree from a list of 3 persons per vacancy drawn up by the lower house of the States General. 2. They shall cease to be members of the resignation or on attaining an age to be determined by Act of Parliament. 3. They may be suspended or dismissed from membership by the Supreme Court in cases to be laid down by Act of Parliament. 4. Their legal status shall in other respects be regulated by Act of Parliament. Article 78. 1. The organization, composition, and powers of the Court of Audit shall be regulated by Act of Parliament. 2. Additional duties may be assigned to the Court of Audit by Act of Parliament. Article 78a. 1. The National Ombudsman shall investigate on request of or of his own accord actions taken by central government, administrative authorities, and other administrative authorities designated by or pursuant to Act of Parliament. 2. The National Ombudsman and a deputy Ombudsman shall be appointed by the lower house of the States General for a period to be determined by Act of Parliament. They might resign or retire on attaining an age to be determined by Act of Parliament. They might be suspended or dismissed by the lower house of the States General in instances specified by Act of Parliament. Their legal status shall in other respects be regulated by Act of Parliament. 3. The powers and methods of the National Ombudsman shall be regulated by Act of Parliament. 4. Additional duties may be assigned to the National Ombudsman by or pursuant to Act of Parliament. Article 79. 1. Permanent bodies to advise on matters relating to legislation and administration of the state shall be established by or pursuant to Act of Parliament. 2. The organization, composition, and powers of such bodies shall be regulated by Act of Parliament. 3. Duties in addition to advisory ones may be assigned to such bodies by or pursuant to Act of Parliament. Article 80. 1. The recommendations made by the bodies referred to in the present chapters shall be made public according to rules to be laid down by Act of Parliament. 2. Other than in cases to be laid down by Act of Parliament, recommendations made in respect of bills presented by or on behalf of the King shall be submitted to the States General. Chapter 5. Legislation and Administration. 5.1. Acts of Parliament and other regulations. Article 81. Acts of Parliament shall be enacted jointly by the Government and the States General. Article 82. 1. Bills may be represented by on behalf of the King or by the lower house of the States General. 2. Bills which require considerations by a joint session of the States General may be presented by or on behalf of the King or by a joint session of the States General insofar as this is consistent with the relevant articles of Chapter 2. 3. Bills to be represented by the lower house or by a joint session of the States General shall be introduced in the House or the joint session as the case may be one or more members. Article 83. Bills represented by or on behalf of the King shall be sent to the lower house or to the joint session if considerations by a joint session of the States General is required. Article 84. 1. A bill presented by or on behalf of the King that has not yet been passed by the lower house or by a joint session of the States General may be amended by the House or the joint session as the case may be on the proposal of one or more members or by the government. 2. Any bill being presented by the lower house or a joint session of the States General that has not yet been passed may be amended by the House or joint session as the case may be on the proposal of one or more members or by the members introducing the bill. Article 85. As soon as the lower house passes a bill or resolves to present a bill, it shall send it to the upper house, which shall consider the bill as sent to it by the lower house. The lower house may instruct one or more of its members to defend a bill presented by it in the upper house. Article 86. 1. A bill may be withdrawn by or on behalf of the proposer until such time as it is passed by the States General. 2. A bill which is to be presented by the lower house or by the joint session of the States General may be withdrawn by the member or members introducing it until such time it is passed. Article 87. 1. A bill shall become an act of Parliament once it has been passed by the States General and ratified by the King. 2. The King in the States General shall inform each other of their decision on any bill. Article 88. The publication of an entry into force of Act of Parliament shall be regulated by Act of Parliament. They shall not enter into force before they have been published. Article 89. 1. Orders in council shall be established by royal decree. 2. Any regulations to which penalties are attached shall be embodied in such order only in accordance with an Act of Parliament. The penalties to be imposed shall be determined by Act of Parliament. 3. Publication and entry into force of order in council shall be regulated by Act of Parliament. They shall not enter into force before they have been published. 4. The second and third paragraphs shall apply mutatis mutandis to other generally binding regulations established by the state. (5.2) Miscellaneous provisions. Article 90. The government shall promote the development of the international legal order. Article 91. The kingdom shall not be 1. The kingdom shall not be bound by treaties, nor shall treaties be denounced without the prior approval of the States General. The cases in which approval is not required shall be specified by Act of Parliament. 2. The manner in which approval shall be granted shall be laid down by Act of Parliament, which may provide for the possibility of tacit approval. 3. Any provision of a treaty that conflict with the Constitution or which led to conflicts with it may be approved by the Houses of the States General only if at least 2/3 of the votes cast are in favor. Article 92. Legislative, executive, and judicial powers may be conferred on international institutions by or pursuant to a treaty, subject, where necessary, to the provisions of Article 91, paragraph 3. Article 93. Provisions of treaties and of resolutions by international institutions which may be binding on all persons by virtue of their contents shall become binding after they have been published. Article 94. Statutory regulations in force within the kingdom shall not be applicable if such applications is in conflict with provisions of treaties or of resolutions by international institutions that are binding on all persons. Article 95. Rules regarding the publications of treaties and decisions by international institutions shall be laid down by Act of Parliament. Article 96. 1. A declaration that the kingdom is in a state of war shall not be made without the prior approval of the States General. 2. Such approval shall not be required in cases where consultations with Parliament proves to be impossible as a consequence of the actual existence of a state of war. 3. The two houses of the States General shall consider and decide upon the matter in joint session. 4. The provisions of the first and the third paragraphs shall apply mutatis mutandis to a declaration that a state of war has ceased. Article 97. 1. There shall be armed forces to the defense and protection of the interests of the kingdom, and in order to maintain and promote the international legal order. 2. The government shall have supreme authority over the armed forces. Article 98. 1. The armed forces shall consist of volunteers and may also include conscripts. 2. Compulsory military service and the power to defer the call up to active service shall be regulated by Act of Parliament. Article 99. Exception from military service because of serious contentious objections shall be regulated by Act of Parliament. Article 99A. Duties may be assigned for the purpose of civil defense in accordance with rules laid down by Act of Parliament. Article 100. 1. The government shall inform the States General in advance in the armed forces are to be deployed or made available to maintain or promote the international legal order. This shall include the provisions of humanitarian aid in the event of armed conflict. 2. The provisions of paragraph 1 shall not apply in compelling reasons exist to prevent the provisions of information in advance. In this event, information shall be supplied as soon as possible. Article 103. 1. The cases in which a state of emergency as defined by Act of Parliament may be declared by royal decree in order to maintain internal or external security shall be specified by Act of Parliament. The consequences of such a declaration shall be governed by Act of Parliament. 2. Such a declaration may depart from the provisions of the Constitution relating to the powers of the executive bodies of the provinces, municipalities, public bodies, as referred to in Article 132a, and water authorities, waterschappen. The basic rights laid down in Article 6. Insofar as the exercise of the right contained in this article other than in buildings and enclosed places is considered Article 7, 8, 9, and 12, paragraphs 2 and 3, Article 13 and Article 113, paragraphs 1 and 3. 3. Immediately after the declaration of a state of emergency and whatever it considers it necessary until such time as the state of emergency is terminated by royal decree, the States General shall decide the duration of the state of emergency. The two houses of the States General should consider the decide upon the matter in joint session. Article 104. Taxes imposed by the states shall be levied pursuant to Act of Parliament. Other levies imposed by the state shall be regulated by Act of Parliament. Article 105. 1. The estimates of the state's revenues and expenditures shall be laid down by Act of Parliament. 2. Bills containing general estimates shall be represented by or on behalf of the King every year on the date specified in Article 65. 3. A statement of the state's revenues and expenditures shall be presented to the States General in accordance with the provisions of the relevant Act of Parliament. The balance sheet approved by the Court of Audit shall be presented to the States General. 4. Rules relating to the management of the state's finances shall be prescribed by Act of Parliament. Article 106. The monetary system shall be regulated by Act of Parliament. Article 107. 1. Civil law, criminal law, and civil and criminal procedure shall be regulated by Act of Parliament in general legal codes without prejudice to the power to regulate certain matters in separate Act of Parliament. 2. The general rules of administrative law shall be laid down by Act of Parliament. Article 109. The legal status of public servants shall be regulated by Act of Parliament. Rules regarding employment protection and co-determination for public servants shall also be laid down by Act of Parliament. Article 110. In the exercise of their duties, government bodies shall be observed the right of public access to information in accordance with rules to be prescribed by Act of Parliament. Article 111. Honors shall be established by Act of Parliament. Chapter 6. The Administration of Justice. Article 112. 1. The adjudication of disputes involving rights under civil law and debts shall be the responsibility of the judiciary. 2. Responsibility for the adjudication of disputes which do not arise from matters of civil law may be granted by Act of Parliament either to the judiciary or to courts that do not form part of the judiciary. The method of dealing with such cases and the consequences of decisions shall be regulated by Act of Parliament. Article 113. 1. The trial of offences shall also be the responsibility of the judiciary. 2. Disciplinary proceedings established by government bodies shall be regulated by Act of Parliament. 3. A sentence entailing deprivation of liberty may be imposed only by the judiciary. 4. Different rules may be established by Act of Parliament for the trial of cases outside the Netherlands and for martial law. Article 114. Capital punishment may not be imposed. Article 115. Appeal to a higher administrative authority shall be admissible in the case of disputes referred to in Article 112, paragraph 2. Article 116. 1. The courts which form part of the judiciary shall be specified by Act of Parliament. 2. The organization, composition, and powers of the judiciary shall be regulated by Act of Parliament. 3. In cases provided by Act of Parliament, persons who are not members of the judiciary may take part with members of the judiciary in the administration of justice. 4. The supervision by members of the judiciary responsible for the administration of justice, of the manner in which such members and the persons referred to in the previous paragraphs fulfill their duties, shall be regulated by Act of Parliament. Article 117. 1. Members of the judiciary responsible for the administration of justice and the Procurator General at the Supreme Court shall be appointed for life by royal decree. 2. Such persons shall cease to hold office on resignation or on attaining an age to a determined by Act of Parliament. 3. In cases laid down by Act of Parliament, such persons may be suspended or dismissed by a court that is a part of the judiciary and is designated by Act of Parliament. 4. Their general status shall in order respect be regulated by Act of Parliament. Article 118. 1. The members of the Supreme Court of the Netherlands shall be appointed from a list of 3 persons drawn up by the Lower House of States General. 2. In the cases and within the limits laid down by Act of Parliament, the Supreme Court shall be responsible for annulling court judgments which infringe the law. Cassation. 3. Additional duties may be assigned by the Supreme Court by Act of Parliament. Article 119. Present and former members of the States General, Ministers, and State Secretaries shall be tried by the Supreme Court to offences committed while in office. Proceedings shall be instituted by royal decree or by a resolution of the lower house. Article 120. The constitutionality of Act of Parliament and treaties shall not be reviewed by the courts. Article 121. Except in cases laid down by Act of Parliament, trials shall be held in public and judgments shall specify the grounds on which they are based. Judgments shall be pronounced in public. Article 122. 1. Pardons shall be granted by royal decree upon the recommendations of a court designated by Act of Parliament, and with due regard to regulations to be laid down by or pursuant to Act of Parliament. 2. Amnesty shall be granted by or pursuant to Act of Parliament. Chapter 7. Provinces, municipalities, Caribbean public bodies, water authorities, and other public bodies. Article 123. 1. Provinces and municipalities may be dissolved and new ones established by Act of Parliament. 2. Revisions to provincial and municipal bodies shall be regulated by Act of Parliament. Article 124. 1. The powers of provinces and municipalities to regulate and administer their own internal affairs shall be delegated to their administrative organs. 2. Provincial and municipal administrative organs may be required by or pursuant to Act of Parliament to provide regulations and administration. Article 125. 1. The provinces and municipalities shall be led by provincial and municipal councils respectively. Their meetings shall be public except in cases provided by Act of Parliament. 2. In addition, the administration of a province shall consist of the provincial executive and the King's commissioners, commissars van de Koning. The administration of a municipality shall consist of the municipal executive, colleague van burgemeester and wethouders, and the burgomaster. 3. King's commissioners and burgomasters shall preside over the meetings of provincial councils and municipal councils respectively. Article 126. The King's commissioners may also be charged by Act of Parliament with the execution of official instructions to be given by the government. Article 127. Provincial and municipal ordinances shall be enacted by the provincial or municipal councils respectively, except in cases specified by Act of Parliament or by them pursuant to an Act of Parliament. Article 128. Except in cases laid down in Article 123, the powers referred to in Article 124, paragraph 1 may be assigned to bodies other than those specified in Article 125, only by the provincial or municipal council respectively. Article 129. 1. The members of provincial and municipal councils shall be directly elected by Dutch national residents in the province or municipality, and as the case may be who satisfy the requirements laid down for elections to the lower house of the States General. The same condition applied to membership. 2. The members shall be elected by proportional representation within the boundaries to be laid down by Act of Parliament. 3. Article 53, paragraph 2 and 59 shall apply. Article 57a shall apply mutatis mutandis. 4. The duration of provincial and municipal councils shall be 4 years unless otherwise provided by Act of Parliament. 5. The position which may not be held simultaneously with membership shall be specified by Act of Parliament. The Act may also provide that obstacles to membership will arise from family ties or marriage, and that the commission of certain acts designated by Act of Parliament may result in loss of membership. 6. The members shall not be bound by a mandate or instructions when casting their voters.